have been thinking how to present this text, so I decided to paraphrase the first part of it, as it is not my text. So by giving the assumptions, and at a certain point I will read this directly from the paper until the time will be acceptable, so until the reading. So first of all, in this paper, the author enlightened the evolution of the mere definition of genocide adopted, the conclusion of this part of consideration can be closed by remark that this definition is a highest achievement of whole evolution, and based on the core definition from the treaty. So, these are consideration prizing the wording adopted in Rome Statute. And then the part of general introduction is about the tools for analysis adopted by the author, which he calls modern tools of criminal law analysis. And those modern tools reflect the conception of Hart and Kelsen and German scholars by distinguishing two norms, sanctioning norms and sanctioned norm. And the statement of author is that he is addressing the interpretation of law, so-called derivative conception of interpretation, created on the Kelsen concept, and the core norm connected with genocide under the statute is a sanctioned norm. It is a very important observation. From this observation, the author put attention to the article 25.1. And from this point of view, let me read the text directly, and I will stop at some point, and then I will make a second paraphrase of the text. So this derivative conception of legal interpretation, which was highlighted before, also emphasizes the necessity to indicate that the central provision containing the indicated norm, the legal qualification, the provision that is the basis for the legal qualification of the offender's criminal act, is Article 25.1. Since the legislator has indicated in this article that a person who has committed a crime under its jurisdiction of the court is individually criminally responsible and punishable under the statute. Indeed, the provision of Article 6, containing obviously definition of behaviors denominated as genocide, is relevant to our consideration as to the provision of that that defines the term genocide. In this respect, only a provision that makes the content of this norm adequate. So this is a very important hypothesis in this work, as the author argued that both Article 25.2 and other also article indicated, and Article 6 are the ground for those sanctioned norm, and at the end, Article 6 indisputably does not indicate the genocide as defined therein as a prohibited act, but just a part of this legal norm decoded after based on both regulation. With the above-mentioned assumption, it is now possible to proceed to limiting the content of the article and the interpretation, the proper interpretation of genocide. This Article 6, it's a collection of several behaviors included in the point A, B, C, D, and E, and each of them create the basis for a separate sanctioned norm. It means that the court, when adjudicating, must expressly indicate which norm has been infringed, and the wrong indication can result in an error in adjudication by the infringe of the rule principle of substantive truth. So when speaking about those norm and base of Article 6, we could distinguish the following sanction norms. The first one, prohibiting the killing of members of the protected group. The second one, prohibiting the infliction of grievous bodily and mental harm on members of the protected group. The third, prohibiting the creation of living condition for protected group calculated to bring about its physical destruction in whole or in part. The fourth, prohibiting the use of measures aimed at stopping birth within the protected group. And finally, the fifth, prohibiting the forced transfer of children of members of protected group to another group. Each of these norms should be obviously supplemented by the information specified the addressees of those norms and circumstances. After all, there is no doubt that the addressee of this norm in principle is each human being, which is inter alia very interesting, as the statute under Article 25 does not imply this feature of being someone who is performing a specific function. So from this point of view, the perpetrator obviously must be selected, which is described here based on case law, but in fact, there is not a formal feature for the perpetrator to be prosecuted before ICC. And the circumstances, and those circumstances are all situations in accordance to Ralph Lemkin's intentional formula that the genocide is a crime both in wartime and peacetime. So the indicated norms, those 6 norms, should also be supplemented with the information specified the form of the subjective side, subjective feature required by Article 6. For each variant of genocide, which is known, the intention is to destroy the protected group in whole or in part. And in some, I don't know whether I achieved this part of presentation, but there are considerations also how to understand and some critical remark that the status maybe does not shape this protected groups as enough, in enough broad sense to codify genocide. The observation that Article 6 of the statute provides a basis for interpreting Article 25.2 in the context of genocide is relevant in cases when the perpetrator has committed genocide by violated more than one of indicated norms. So in the cases when we must indicate more than one of sanctioned norm indicated the range. Speaking about this situation, it is called the legally complex situation that must be reflected in proper way in the legal qualification. And now to maybe present the most, in my opinion, my humble opinion, insightful comments are the comments connected with the co-perpetration in respect to genocide, and then those connected with the group protected. So then the part of the speech is about the interpretation of Article 25.3 based on genocide, and I can read following the author that it should be pointed out that this provision, I mean Article 25.3a, indicates that the previously distinguished sanctioned norms prohibiting genocide shall also be violated jointly with another person. This framing constructs the formula of co-perpetration. As it is well known, the theory of criminal law draws attention to possible doubts as to whether it is a co-perpetration in the case of arrangement characterized by the division of rules. Arrangement when the co-perpetrator do not realize all the objective elements, actus reus of aforementioned variant of the genocide, but only realizes part of them. When accepting the variant that the co-perpetration consists of partial realization of statutory feature of the given crime, given case genocide, and this variant is supported both by jurisprudence of ICC and literature. Then another sanctioned norm is introduced to the legal system. So there is a supplemental new qualification that must be reflected when adjudicating, or even before, during the earliest stages. So debatable from the point of view of normative analysis is the status of the crime of genocide committed throughout another person. Behavior which, it should be believed, has the closest connection with the construction of indirect perpetration. The construction of indirect commission is substantially questionable in by national scholars in national legal orders, as it based on assumption that the prohibited act's commitment is possible by a behavior different from that of the perpetrator, direct perpetrator, based on Article 6, the behaviors indicated in point A, B, C, D, and E. The problematic nature of this construction, indirect perpetration, is also a result of its dependent accessory character. After all, it should be recalled that the condition for a realization of indirect perpetration is the performance of the forbidden act by the direct perpetrator, with the result that the non-performance of the crime of genocide entails the absence of indirect perpetration. However, there is no doubt that in the modern theory of criminal law, constructions based on such dependency are abandoned, as individualistic perspective is generally adopted, because such constructions violate the standard of equality and are incompatible with the scheme of legal norm presented in the first part of the speech, which I just paraphrased. Most significantly, however, the framing of the form of perpetration of the crime of genocide appears as violating the principle of nullum crimen sine lege. And this is so because the provision of Article 25.3a of the statute does not indicate what the conduct of perpetrator would consist of in the case of indirect perpetration. The connection with indirect perpetration suggests that the idea that discussed concept is based on the conduct consisting of directing the execution of a crime of genocide and instructing a person dependent on the person who gives instruction to execute that crime. The question of the sanctioned norms prohibiting indirect perpetration is, therefore, one that requires deep-in-depth analysis. Hence, to the rule of the ICC case law cannot be overestimated, and there are some remarks on the cases, also the cases of ICT, which impacted to the great level, at the great point, the evolution of the mere notion of genocide. An adequate clarification of perpetration throughout another person by the elements of crimes should be recommended. Of course, this recommendation might be problematic due to the wording of Article 9.1 of the statute, as this provision verbal legis indicates that the elements of crimes are only intended to assist in interpreting and applying Article 6, 7, 8 of the statute. However, it would appear that the close connection between the crime defined in these provisions and indirect perpetration, a connection in that direct perpetration is a means of committing the crime, ultimately allows for including such an explanation into elements of crimes. The question how to frame this definition would require insightful research. However, it could already be satisfactory if this definition were to be formulated by indicating that indirect perpetration is an act of directing or ordering the execution of a crime by a person who is actually or formally dependent on the principle. On the other hand, the conduct set out in Article 25.3b poses fewer difficulties as behavior being forms of indirect perpetration. In case of behaviors typified in Article 25.3.b, sanction norms are separated from norms prohibiting particular varieties of crime of genocide typified in Article 6. This is so due to the indisputable fact that the conduct indicated is of a different kind from the conduct defined in Article 6. They may therefore be referred to as so-called non-executive forms of criminal collaboration. It is also worth emphasizing that in case of non-executive forms, the violation of sanction norm is independent from the execution of the crime of genocide. In short, the crimes set out in Article 25.3b are so-called formal offenses. Additionally, it should also be pointed out that the wording of Article 25.3b is not perfect. Indeed, it is superfluous when listing persuasion alongside inducement, as, according to the semantic perspective, persuasion is a means of inducement. The scope of Article 26.3c of Statute, on the other hand, raises serious problems of interpretation. This provision, in fact, criminalizes the contribution to commission or attempted commission of the crime of genocide caused by the purpose of facilitating its commission. The mentioned article indicates that aiding and abetting are examples of how this contribution can be realized. However, it must be emphasized at once that the aiding and abetting mentioned in this provision are, unfortunately, flawed construction from the legal stance as far as they do not indicate the connected behaviors to be associated with. In short, Article 26.3c does not indicate neither the conduct to which aiding and abetting would be relativized, nor the conduct to which the instigator would incite. The exemplary enumeration of aiding and abetting formulas in Article 26.3c fails, for the above reasons, to fulfill its intended rule, because it does not bring us any closer to understanding the term, the contribution to the commission of or attempted commission, the expression quoted, of the crime of genocide. Consequently, in addition to the explanatory interpretation of ICC is also important, and maybe I will pass to the last part, as there are plenty of consideration to each point of Article 20, 26 and the other. And in the last part, the author reflects that the normative analysis outlined above, the given definition of genocide under the statute sometimes is somehow different from the definitions adopted by national legislators, and there are plenty of consideration of those inconsistency. And at the end, maybe to mark the Polish accent, the definition is quoted from the Polish Penal Code. It is Article 118. According to this article, anyone who murders or causes grievous bodily harm to a person belonging to any ethnical, racial, political, religious group, or a group with a different perspective on life, with the purpose of partly or completely annihilating such a group, shall be responsible for some indicated penalty. So these considerations are about the proper shape of the protected group and whether the definition inserted into the status is acceptable and is also in line with the challenges of nowadays when it comes to the protection of specific groups. So thank you for your kind attention, and it will be in the written form.